A negotiation typically involves two or more parties attempting to reach an agreement. Negotiations generally involve the parties exchanging something they have for something they want. What most law students and young lawyers do not realize is that negotiation may not always be in the context of a dispute. On the contrary, negotiation is really just an essential part of doing business, as it often determines the terms on which business takes place. Negotiation is equal parts art and science. However, after all these years and several negotiations, I have discovered that even the most experienced negotiators lack a framework that grounds their approach to negotiation. Some lawyers try to bully their way to the lion's share. Others advance arguments that sound fair to them but may not be equally fair to the other side. Still others try to exhaust you into submission. The truth is that none of these tactics works. Instead, I believe that it's important to focus on principles that will encourage the way you approach negotiation, both as a lawyer and in life. Before we begin, let's set the paradigm for a negotiation. Here's the number one mistake that amateur negotiators make. They assume that negotiations are a zero-sum game. They believe that there's only one winner and that the purpose of being at the negotiation table is to win as many points as possible. My experience tells me otherwise. For one, most negotiations, especially in corporate deals, are not zero-sum. If you are representing a venture capitalist in an investment round for a startup, it may be tempting to bulldoze a young founder into appalling terms. But eventually, if the founder and your client investor are not on friendly terms, both parties lose. The popular notion that you have to be selfish, manipulative, or even abrasive to be a good negotiator is false. You must recognize that it is okay to say no assertively and credibly when necessary. The three fundamental assumptions that will make any negotiation better are: first, always be trustworthy and reliable. This reputation is a great advantage at the negotiation table. Second, always be fair to those who are fair to you. A fair negotiation is a good negotiation. Third, you should let others know when you think the other party has treated you unfairly. Though much of the terms agreed involve being cooperative, this doesn't mean that anyone gets bullied or steamrolled.
In the fast-paced world of corporate law, tomorrow's legal leaders need to be more than just traditional expertise. Introducing the LLM in Corporate and Financial Law, a groundbreaking program brought to you by Jindal Global Law School in partnership with upGrad. Designed for the legal professionals of tomorrow, this innovative blended learning program combines academic rigor with real-world application. Don't miss out. Click the link in the description to elevate your career with the LLM in Corporate and Financial Law.
A negotiation doesn't begin at the table. In fact, it often begins a long time before that. Usually, the paradigm for a negotiation is set by the context. In the context of a commercial practitioner, this could be a contract. If you are negotiating a dispute, it's often the facts of the dispute. Now, since every move matters, it is vital to be well prepared. Good preparation involves spending time to consider a number of different aspects. First is the law. Not knowing the law, especially as a lawyer, is criminal. For instance, if you are negotiating a deal where a poker company is being acquired, not knowing the legal position on poker would be a big red flag. You simply will not be able to negotiate aspects like reps and warranties without such legal knowledge. Then you need to know the client. It's important to be aligned with your client. Some clients have a much greater risk appetite than others. Some place a greater priority on speed than others. You need to modify your approach accordingly. You also need to know your position. Every negotiation begins with a position. One party may want more consideration, the other party may seek unlimited liability, or both may aim to ensure that they are 100% protected from risks. These are the different positions that the parties may take. It's crucial that you know your position before entering the room. Your position is intrinsically linked to your BATNA. Now, what's that? BATNA is an acronym that stands for Best Alternative to a Negotiated Agreement. It is the most advantageous option that a negotiating party can take if negotiations fail. Let's take an example. You are at a taxi stand, looking to go home. The typical fare is Rs 40. If there are multiple cabs available, then the driver will charge a lesser fare since he knows that you have more options. However, if there's only a single taxi, then the dynamics change and the driver may quote a higher price. In the latter situation, your BATNA is weak. Simply put, your position is directly proportional to your BATNA, which means the better your BATNA, the stronger is your position, and inversely related to the counterparty's BATNA. The worse their BATNA, the stronger your position. Good negotiators assess the interests behind the parties' positions. They do this by asking why. Without understanding the why, a position has no purpose. Let me repeat the famous example of two sisters arguing over an orange. Both these sisters wanted the same orange. Without understanding their interests, you would be inclined to split the orange equally. However, if you ask them why they needed the orange, you would find that one sister wanted the rind to make marmalade, while the other wanted the pulp to make juice. The best case scenario, therefore, would be to give the entire pulp to one sister and the entire rind to the other. This shows that the solution may not always lie in responding to the party's position. Rather, it's better to address the interests behind those positions. The most critical aspect at a negotiation is to identify interests behind a position. What is it that you really hope to gain? What would change to make you happier or more satisfied? While negotiating a specific aspect of a deal, you could either have complementary interests or conflicting interests. A simple example of complementary interests is exclusivity. Both parties may benefit from exclusive arrangements. Subject to the law allowing such arrangements, of course, both parties can gain from such complementary interests. On the other hand, there is a possibility that your interest directly contradicts with that of the other party. For instance, if you are looking at something like an indemnity provision, your protection is balanced against the risk exposure to the other party. Even in this scenario, it is crucial to understand the interests of both parties to arrive at the outcome that leaves both parties satisfied, even if they have both made concessions.